Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube.
So basically, this article talks about uh, a very interesting kind of thing. Suppose you get a seat in the CLAT examination and you are offered a college of your choice, and there you find a BTech LLB, a BBA LLB, Bachelor of Business Administration and LLB degree, and you have the option of pursuing a BLLB. And then there is a program of BCom LLB, that is B Commerce and Bachelor in Commerce and LLB. And then there is a program in what we call as BSc and LLB. Would it not be interesting? And then there is, of course, a program on BA LLB. So this is very, very interesting. So what is this happening here? Majorly, you'll be studying the law, but you'll have insights from depending on the stream you are choosing, whether it is from sciences stream, pure sciences, or whether it is applied sciences, that is the technical sciences, or you are taking the business administration courses. So this is something which is, you have a wide variety. Some of the national law schools offer that, and that makes it very, very interesting. Likewise, in the IITs, they are trying to integrate. Once President Kalam said that science requires foundation of liberal education. So you had the shift is towards an integrated program wherein you have a cross-disciplinary or interdisciplinary approach, where you use insights from other fields to enrich your core field. For example, you use insights from economics into law, or insights from psychology into law, or insights from sociology into law, or for that matter, insights from anthropology into law, or for that matter, insights from technical education into law. So you try and come up with an integrated solution, and that solution is more valuable. It is valued more in the industry. It is valued more in the industry because it is closer to the reality. You are not operating in what they call as silos. That is, you don't have a compartmentalized approach, but you have an approach which is an integrated approach, which is a holistic approach, which brings multiple perspectives and deep and diversified insights to approach the same problem. We are basically facing, we are looking at the same problem. For example, when an accident takes place, then somebody is looking at it from the perspective of road design, that what was defective in the road design that the accident could not be prevented. So say it is not bilaning, or say it is not one-way traffic and something like that. So it is a road design. Something is looking at it from the perspective of say legal perspective, that is the speed limits and the laws in the Motor Vehicles Act and so on and so forth. So instead of looking at it in a compartmentalized way, why don't we look at it in a holistic way, in which the lawyer also looks at the scientific data and tries to come up with better insights on policy framing. So this is what the article is about. And coming specifically to the article basically says that we are copying from the American model. Now, regarding the copying, there's nothing wrong in taking ideas from anywhere in the world. Of course, we will have to adapt the ideas to suit the Indian conditions. Because in the United States, when the concept came up, they came up in a very organic way, and the 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 thing evolved in the context of a market and in the context of a thriving, rigorous academic ecosystem, which is absent in India, because National Science Foundation has come up, but majorly our country lacks in research. Therefore, this kind of program, if it has to be implemented, it has to be implemented in an adaptive manner, and it has to be implemented keeping in view the limitations of our institution and limitations of our staff, teaching staff, and their training also becomes important. Besides, funding and budget are also required for this kind of thing. Besides, the number of institutions that we have may not be adequate for the clustering approach that the author says. The author himself identifies that there are so many B.Ed colleges, and B.Ed colleges are the most, the biggest fraud on the educational map of India. Today, B.Ed colleges are just for making money and nothing else. They don't provide any value whatsoever, except the good ones. The good ones, of course, and there are hardly any in the private sector in the good ones. Almost all of them are in the public sector. So this is what the article talks about. The article brings about very interesting insights about cross-disciplinary and multidisciplinary campuses. Articles also draws distinctions between multidisciplinary course and a cross-disciplinary course. A cross-disciplinary course basically goes beyond the multidisciplinary course. Multidisciplinary, you may have several multiple disciplines, but then to use insights to cross-fertilize ideas across various disciplines, that we can make it truly cross-disciplinary. I may give an example. When Professor Mitra at National Law School and myself were working on the FRBM, Fiscal Responsibility Budget Management Act, then we used insights from economics and we used insights from law, merge the two, from constitution, from economics, from cross-cultural experiences, and then try to come up with a solution. And eventually that was drafted by the high-powered committee, which was appointed by the government of India, of which Professor Mitra was a part, and I was the national vice chancellor of National Law University at that time, and I was his research assistant. So we jointly published an article. You can access that article in one of India's most prestigious journals, which is the journal which is published by ILI, Indian Law Institute. So we came up with a 64-page article and outlining the idea behind, that is a cross-disciplinary kind of thing, which is very interesting. But at the same time, it has certain pitfalls in the sense that you don't really get on terms with the other part, which is not a major part. But that is not a reason you should not venture there. You must venture there. Besides, several medical institutions, first-rate medical institutions, PGI Chandigarh, and I don't know about AIMS, but I know about PGI Chandigarh. You have when an X-ray is done, then the resident doctor, when he looks at the X-ray, he tries to look at the original file which is given of the X-ray, or for that matter, of the test which has been done. Now that is, he is combining insights of radiology with his core competence. So that kind of cross fertilization and cross competence is encouraged in some of the premier medical institutions as well. I am aware of that. Anyway, now 26th question: who has marked it incorrect? Whoever has marked it, let us change the system a little bit more. Whoever marks a question incorrect, he will take up that question. If two students have marked it incorrect, then they can do it alphabetically. Do you follow what I'm saying? Suppose this question 26 is there. I think Tanishka has marked it incorrect. Somebody else may have marked it incorrect too. But then whoever has marked the question incorrect, he or she will have to take up that question. Right? So please take up the question and quickly discuss it. Because today I am hell-bent on discussing 4 articles of legal also and 2 articles of this. You will easily come to know by looking at your side of the copy who has marked it incorrect, because it will show in the red if you have marked it incorrect. So quickly take it up. Don't waste so much time. There must be some volume of work also. Apart from quality, volume is also required. And I have already fixed the parameters for volume. 4 articles from legal, 4 articles from logical per day. Means 2 days we have to finish 1 paper. So encouraging students to explore. I am on question number 29, right? Encouraging students to explore multiple disciplines from the start is crucial for building future interdisciplinary, so on and so forth. Okay. Then clustering single stream colleges guarantees better interdisciplinary research outcomes. It doesn't, because the author says it is multidisciplinary or interdisciplinary research papers are finding it difficult to get published. So India's higher education system will naturally evolve. No, it will not have any natural evolution like the US. That is why we are trying to have an adaptive evolution. Humanities and social sciences should replace. This is neither here nor there. Chaliye. Then this is okay. Come to the next paragraph, please. The one of the goals of the Paris Agreement is to decarbonize the planet, and nations have undertaken voluntary decarbonization uh, goals. India has committed to net zero by 2070. Um, Other countries have taken different goals. So by 2070, we have to decarbonize and we have to become a net zero emission country. So 2070 is a long way off. And this article basically suggests a way out of promoting the use of hydrogen. He says that the problem with the problem with solar energy and wind energy, those are the renewable sources of energy. The hydroelectricity is also considered to be a renewable source of energy. So the problem with this is the unpredictable nature of output from these sources, because they are dependent on the vagaries of climate or the weather. The wind does not flow, or the sun, it gets cloudy and sun doesn't shine. Then the production is variable. Now the variability of this production is very well um, supplemented by the help of carbon, in the sense that it is very flexible, and you can power the carbon furnace to produce electricity the way you want. Now the author sees this as a goal for substitution, because this will have to be substituted. Then the author tries to understand whether we can substitute the flexible nature of the thermal power generation, that is the coal produced electricity, whether we can supplement this by nuclear power. Now the author also says that we have very aspirational goals for promotion of nuclear power in a big way in the coming this thing, and we will have an installed capacity for 700 megawatts of nuclear power. Now, now we will now the the problem that this poses to the author is that the flexing, using this as a supplement to the renewable energy generation through sources of solar and wind is very difficult, because the technology is not mature. And besides uh, pressured heavy water reactors technology, which is mature, is not suitable for this kind of variable payload. So this is not going to work out. And even if it works out, then the economic cost would be unbearable. So that is not an option. Then what option remains? The author seems to suggest that instead of let us use the fickle-minded or vagarious nature of the renewable energy production, that is solar and wind produced energy. Wherever it gets surplus, you use that energy, surplus energy. Don't store it. If you store it, the storage options are counterproductive because of the huge cost that is involved. Now that requires lithium mining and mining for other critical minerals which are in short supply, and which mining also causes a lot of environmental pollution. So the author does not go into all that. He basically confines himself to the problems that that are there in replacing carbon-based fossil fuels as the supplementing source for electrical energy generation. So he says that let us look at the problem in a different light. Instead of investing too much in storage, let us generate hydrogen. Whatever, suppose sometimes solar electricity uh, generation is weak. Sometimes solar generation electricity is in excess. So whenever it is in excess, then we can use that excess solar energy or excess wind energy for electrolyzing water in order to produce uh, hydrogen. And you can store it also. There is no problem. And then you can use it as a fuel in the most polluting industries such as steel or cement or fertilizer production and so on and so forth. You can use hydrogen, and so you replace carbon with hydrogen. So this is how he proposes that you electrolyze the water, you generate the hydrogen. Given the fecal and gregarious nature of the renewable energy production, let us do it this way. Instead of storage, let us put it into generation, hydrogen generation, and then use it wherever the use is to be put. And then the storage is also not a problem because storing hydrogen is not at all difficult. So storing electricity is very difficult. So instead of putting your energy into storing electricity, let us put our energy into generating hydrogen. This is what the article in essence talks about, right? Now let us come to the picture. All right. So basically the article talks about what are the consequences which follow when you have a criminal conviction. Here, the criminal conviction basically concerns an elected sitting MLA and sitting MLA threatening public officials on duty and demanding a recall uh, while using violence. So the consequences are that he loses his seat for 6 years, that the right to contest the election for 6 years. 6 years means effectively he loses the right to contest for 10 years, for 2 terms. So that is a very big this thing. 5 years, one and plus 1 year more. So 6 years basically, effectively, it means you lose for 10 years, two electoral terms, number one. Number secondly, you will lose, the moment you are convicted, you will lose your membership of the assembly. This happened in Rahul Gandhi's case also, when he was convicted. And in this case also, this has come about. And then there are certain definitions. There are three definitions which have been used. One is theft. Theft is basically taking some property out of another person's possession, right, without consent. That is theft. Now, various illustrations are provided to understand the concept of theft. Now, then, secondly, there is another one which is extortion. Basically, putting somebody into a fear of immediate hurt, um, and then you take out property. So one has extortion is different from theft in the sense that extortion, you are inducing the delivery of property by putting the property holder in fear of hurt or grievous hurt or whatever, and or somebody who is known to him into these states. Whereas in theft, you are taking from somebody else's property, but you are not you're using threat. You are not inducing the delivery. You are taking out of the possession without consent. So in extortion, the main thing is that you take it out from another person's possession, but that taking is when another person gives it to you, right? And how does this giving come about? By use of threat of grievous hurt or threat of homicide or something like that. So in which the person put under threat delivers the property, but it is not a voluntary delivery; it is a coercive delivery. Whereas in case of theft, There is no coercion which is being used. You are taking here from the custody of another person, the lawful owner, or the lawful holder, or the de facto holder, and you are not using force, but you are taking it out without his consent. So that is basically the difference between theft and extortion. One includes taking something from the custody of another person without his consent. Another includes putting somebody known to the property holder or the property holder himself into some fear of injury and then inducing delivery of the property. That is the difference between theft and extortion. And when do they become robbery? They become robbery when violence is used. So that becomes either theft or extortion coupled with violence. That makes it a robbery, right? Uh, uh, so this part is important, which all of you have overlooked. And on this part, the questions are being framed. Now, please come to the questions which are there. For 83 is correct. Need not bother. 84 okay. 85 is not correct. I think both two responses are there and both of them are incorrect. So either one may take it up. Please take it up. Yes. So when you cut a tree and take it away with you, then you'll notice explanation 1, and I'm sharing the screen. I hope this is visible to you. A thing so long as it is attached to the earth, not being movable property, is not subject of theft, but it becomes capable of being subject of theft as soon as it is severed. So severing is what brings about the theft. Okay. Whoever intending to take dishonestly any movable property out of the possession of any person without person's consent moves that property is said to commit theft. So, which are the essential ingredients of theft? First of all, the property must be movable. Secondly, it must be into possession of somebody. If you are finding a coin lying on the road, then if you pick up the coin and put it in your pocket, it is not theft because it is not in anybody's possession. It is lying on the highway. So this can't be a question of theft because it must be movable property, number one. Number second, it must be in possession of another person. If it is not in possession of anyone, how can there be a theft? From whose possession have you taken it out? Then, without the person's consent, if it is consensual, then the question does not arise. If you have an entitlement to the property, you may use violence and snatch it back. It won't be theft because in any case you are the owner, you are entitled to it. So the question of consent does not arise. So without the person's consent, then moves that property. There must be some movement in the property. If you think in your mind that yes, I will commit a theft of this property, it won't become an offense. It may be preparation. It won't be even an attempt. But in order to actually translate into an offense, there must be moving. Moving is very, very essential. Now, in moving, regarding the concept of moving, explanation B is very important. Explanation to the moving affected by the same act which affect the severance may be a theft. So the moment the severance is there, severance itself is a movement. The moment you cut the tree, therefore, if you read 1 and 2 together, you will understand that if something is an immovable property, it can't be a subject matter of theft because subject matter of theft can only be a movable property as it is defined in the section. Nevertheless, if it is an immovable property and it has been severed from the ground, then it says that the act of severing itself is the movement because there is a need of a movement under the section. Moves that property. You must move. So he says severance itself is movement. I hope this is clear to you. You are with option A. But all right,
Yes,
that's
sir.
okay. I'll explain. So the moment you give a bait to the dog and the dog starts following you in the consequence of the bait, so there is a movement, right? The moment and the section, what does the section require? I'll just take you to the section once again. Here it is. Without that person's consent, moves that property. The first moving is sufficient. The dog was not following itself. The dog was following in consequence of the bait which was given. which he ought not to have been given. If you give a bait, it's all right, no problem. Not a bait. If you give something to a dog to eat, there's no problem, because there's no dishonest intention, right? The moment you give a bait or give something to the dog with the intention of taking the dog out from the possession of the lawful owner, it becomes that. A physically picks up the dog. You can, that is neither here. Come to the section, apply the section. What it says, intending to take dishonestly, that is dishonest intention. The moment you say that there is a bait, it means there is an inducement. That means you want the dog to take a particular course of action so that you can physically lift it at a later point in time, right? Out of the possession. The moment it is moved out of possession, and then he says without that person's consent. Here there is no question of any consent because he is using a bait. Then moves that property. The first movement is sufficient. Just like in the tree example, as long as it is attached to the earth, not being movable property, not subject, but capable of being subject of that as soon as it is severed from the earth, and the severance itself is attached. So the first movement is sufficient. The moment the first movement is taken, moving in first instance of moving has taken place, matter comes to an end. You have actually, now please come to section explanation 3 also. A person is said to cause a thing to move by removing an obstacle which prevented it from moving and separating it from any other thing, as well as by actually moving it. So this should clear your doubt. A person who by any means causes an animal to move is said to move that animal. And to move everything which in, please come to 3. Said to cause a move by removing an obstacle. Even if you untether the dog or untether a buffalo, or you untie the chain with which the animal is tied to the what we call as the pillar, then even that is sufficient. That completes the offense. So here the moment the bait comes as a consequence of the bait, even with the dishonest intention of taking the dog out of possession of the lawful owner, the moment the bait is offered, that is the first moving, and first moving is sufficient to make the offense complete. Nothing else is required. Is that all right? Can I move further? All right. Please come to question number 87. I think both options are incorrect. So Tanishka, you take it up. Criminal liability constitutes of 2 parts. Number 1 is dishonest intention, guilty mind. Also, it is called guilty mind. It is also called the mens rea or the mental component. That is, dishonesty is very important. Dishonesty means claiming something to which you are not lawfully entitled. That is dishonest, right? And number 2 is the actus reus. The act must be completed. Suppose you are thinking in your mind, then it may be preparation. Preparation is not punishable. Then you may take some preliminary steps. It may be an inchoate attempt. That is also not that is not the offense. You take you can say that this is breach of trust. You can say, or you can say it is misappropriation of property. But then if you say that he has committed breach of trust, then too there must be a dishonest intention. Here it is a necessity. So breach of trust will not also be there. He said that I badly needed money, I have returned it. Matter comes to an end. If you have to say that he did it because of the dishonesty, he wanted to swallow. He wanted to. He doesn't want to, return the benefit, and he did it intentionally. That kind of thing to attract criminal liability. So criminal liability requires 2 things. And where it is written in this section, I shall tell you. Intending to take dishonestly. This has to be proved as a matter of fact. Here it is necessity. So there is no question of any fact. There is no question of any breach of trust. There is no question of any criminal misappropriation also, because this will be absent in all of them. And this is required to be present in all of them. For example, let us take up extortion, where it is present. Whoever intentionally puts person in fear of injury. Suppose I accidentally put somebody in the fear of injury. No criminal liability. Intentionally I must put. Dishonestly I must put. I must put with an intention to gain to which I am not lawfully entitled, or to lose something to which I am lawfully entitled, or to make somebody lose something to which he is lawfully entitled, or to gain something from somebody to which I am not lawfully entitled. The intention is very important. Mens rea is very important. If the mens rea part is absent, there will be no criminal liability. Is that clear to you? A finds a ring in the high road, not in the possession of anyone. Why? What is required? Please come to the theft once again. What is required in theft? Theft is this. Here it is. Out of possession of any person. Where is the possession of any person if you find it on a highway? You follow? See the section very carefully. Criminal liability requires a strict interpretation. Each and every word is important. Is that okay? Is that clear to you? Yes, obviously, because it doesn't matter the moment he moves it out of possession, even if it is lying there, but the owner doesn't know where he has hidden it, and he has a dishonest intention. Fearing search and detection. Where is the dishonest intention? Fearing search and detection. So he doesn't want this to be known to anyone because he has a guilty mind. The moment you have a guilty mind and you hide it, moving has taken place. The moment it is taken out from somebody's possession, even though it is within the same building, or even though it is. So you are right that Z carries shop, but then A without owing Z any debt that would justify lawful detention enters the shop openly, forcibly takes away the watch from Z and carries it away. Now here it can't be theft. It can't be extortion also because it is his property. You may be guilty of using criminal force. That's all right, but that is something else. It is not. What option is correct? A is obviously incorrect. A has committed the offense. No, because there is no dishonest intention here. It is his own property. He has taken it away. Then A has committed the offense of extortion. No question at all, because he has not caused any inducement for delivery of property. Since force was used, the offenses of robbery. Robbery can be there only if there is an offense of theft. Before foregoing offense of theft should be there, or extortion should be there. Neither theft is there nor extortion is there. There is no question of any robbery. None of the above will be correct. It's all right. Then you have 91 is correct. Then you have 92. Which both answers are incorrect. It's all right. You take it up. Or intentionally puts any person in fear of any injury to that person or any other, and thereby dishonestly induces the person so put in fear to deliver to any person or any property valuable security, so and so. That is extortion. So extortion requires what? Of course, one is the guilty mind. That is the dishonest intention. That is number one. Then fear of injury must be there. All right. Here, that is extortion. But when does extortion become robbery? Please come to this one. This is where. Where is that? When theft is robbery, when extortion is robbery. Extortion is robbery if the offender, at the time of committing the extortion, is in the presence of the person put in fear. Here, he is in presence of the person put in fear. Yes or no? Yes or no? As per the suggestion, as per the fact situation, A meets Z and Z's child on the high road. A takes the child and threatens to throw the child down a precipice unless Z delivers. Z, fearing harm to the child, hands over his purse. So he is in presence of Z who is being extorted. So the moment the extortion is committed in presence of the person put in fear, then it turns into robbery, which is an aggravated offense. All right. So it would amount to robbery and not merely extortion. Right. Then explanation also makes it clear. The offender is said to be present if he is sufficiently near. Even he may not be very proximate. He may be at a distance also. Then too, it will become robbery. Extortion will convert into robbery. Robbery is punishable more stringently than mere extortion. All right. Is that okay? Question number 93. I don't know how it popped up here. It has nothing to do with the passage. I don't know how it suddenly came here. Anyway, let us do it when it has come. But we have done 10th schedule of the Constitution, disqualification and all that, right? And judicial review power. Please, this is correct or incorrect? This question is marked correct or incorrect? Basically, so one speaker's decision is final. That's all right. That doesn't mean it will not be subject to judicial review, but it has finality. in the sense that there is no other court of appeal. Judicial review is different. The speaker exercises discretion. The moment the speaker exercises discretion, the moment you exercise discretion, then there is no question of decision on merits. These are contradictory, because constitutional judicial review on the grounds of constitutionality or legality basically goes to procedural review. It is not review on merits. If a discretion has been vested in the president to impose an emergency, then the courts are not going to review whether or not the president was right in imposing the emergency. Likewise, if the discretion is vested in the RBI to determine the economic policy, then the courts are not going to review the economic policy of RBI. They are not going to sit in judgment of the RBI. Likewise, where the discretion is vested in the speaker, then courts are not going to say how the speaker has to exercise his power. He knows what he has to do. He is the best subject matter expertise he has. We will only exercise on a limited constitutional violation or a procedural irregularity or a violation of somebody's fundamental right. So all these things are there. That much review we will do. We will look at it from a constitutional perspective, from a fundamental rights perspective, from the perspective of procedural fairness, but we are not going to review the decision on merits. That is how it goes. And third is speaker's disqualification proceedings is subject to judicial review. Yes, it is subject to judicial review, but that does not mean you throw away the power of the speaker and then substitute your own judgment. No, speaker is a specialist in his own domain, and his discretion has to be respected, and the courts will respect his discretion, subject to the compliance with the provisions of the Constitution, fundamental rights, procedural fairness, and all. All right. Come to the next one. All right. So basically, this is about common intention. What is common intention? Suppose 4 people come together, and one is standing watch, another is committing the act of bank robbery, another person is moving the people out of the locker room of the bank, another person is threatening the bank employees. So what offense they have committed? There is a preconcert. There is a prior meeting of mind. There is a plan that they are executing. Since they have a plan, since they have a prior concert, their actions are premeditated and inspired by a plan or instigated by a plan. Therefore, they are liable for each is liable for the entire act and not merely for the offense he has committed. What is the meaning of that? Meaning of that is, suppose somebody slaps the branch manager. Then he says, Baba, what have I done? I can be liable only for what I have done. And what I have done is caused a hurt to the branch manager. That's all. Catch the person who has broken the locker. Catch the person who has taken other steps to break the locker or who has removed the valuables from the lockers of people. You catch them? No. If there is a plan, if there is a forethought, if there is a premeditation and a concert, if those things are proved, all of them are liable, irrespective of what part you have played in that crime. That is the principle. There is no principle of vicarious liability in crimes. There is only that is why they scrupulously avoid the word vicarious liability. Vicarious means one person does the act, another person is liable. Where have we read that? We have read that in master-servant relationship. We have read that in a partner or principal and agent relationship. The information given to the agent is information given to the principal. The act done by the agent is act done by the principal. Likewise, the act of the servant in the course of his lawful duty is the act of the master. These are instances of vicarious liability. There is no such thing as vicarious liability in criminal law. You are liable for your act and nothing else. You are not liable for somebody else's act. Suppose 3 people go on a picnic. Three young kids go on a picnic. On the way, one of the kids picks somebody's pocket about which the 2 other are not aware. So there is no preconcert. There is no premeditated plan. There is nothing in which they have had a meeting, and in that meeting they have formed a carefully designed strategy or a carelessly designed strategy. It makes no difference. So whatever is done is an act of an individual in picking the pocket of anyone. So he will only be liable, the other two will not be liable. Is that clear to you? I guess this is a simple, straightforward, short article. We need not spend so much time on this. There are no questions also in this. All of the questions you have answered correct. So your understanding is already perfect. Let us not waste our time on this. All right, it seems you have not read it. So let us take it up tomorrow. And tomorrow we will complete the logical reasoning. We will also complete this one question. So please bear that in mind. And secondly, let us meet tomorrow at the same time.
The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.